Hello all and welcome to the special joint City Council, Planning Commission, and Architectural Review Board meeting. Today is Monday, March 16th, 5:36. Roll call, please.
So of the City Council, Councilmember Clark.
Here.
Councilmember Mayer.
Here.
Councilmember Nomura.
Here.
Vice Mayor Solorzano.
Here.
And Mayor Alarcon.
Here.
Of the Planning Commission, Commissioner Benefield. Here. Commissioner LaFevers.
Here.
Commissioner Van Antwerp. Here. Vice Chair Moyer.
Here.
And Chair Allen.
Here.
And from the Architectural Review Board, Board Member Wolf. Here. And the record will show, as of now, Board Member Johnson, Board Member Little, Vice Chair O'Connor, and Chair Blakemore are absent.
And I also mentioned that those members are also being contacted via phone. We will now, if you are willing and able, please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. We will now move on to our only item on our agenda today, which is an update on new 2025 state housing laws.
Thank you, Mayor Alarcon. Good evening, everyone. Thank you for joining us this evening. Each year, we do a version of this presentation to share with the Council, the Planning Commission, the Architecture Review Board, and the greater community a summary of some of the applicable housing laws passed by the state legislature in the past cycle that took effect on January 1 of this year. We don't expect this briefing to make you all experts in all these housing laws, but it's really just meant to give you an introduction to them, to give you a little bit of background in them, so that when or if these laws are invoked on future projects that come before your various decision-making bodies, you hopefully have some passing familiarity with them. Of course, as projects come before you and invoke some of these laws, it's staff's job to help provide finer grain level of detail, answer questions, give you some background and some parameters to work within. But again, this is really just supposed to be kind of an educational, first impression, first exposure to these laws. I wanted to also mention that in terms of helping to educate the community and decision makers about some of these housing laws, we are working to create a series of frequently asked questions that relate to housing laws, and we'll be posting those to our website. They'll be high level, but they will link to other places where you can find more information, and we also intend to link to both this year's report of housing law updates as well as previous year's updates to provide a resource that, again, your decision-making bodies or the general public can go to as a kind of a quick index to find information about some of these different laws. With that, I'm going to hand it off to Matt Carlson and Cody Sargent from our City Attorney's Office, and they're going to be doing the heavy lifting tonight and walking you through the recent updates.
Good evening, City Council, Planning Commission, Architectural Board of Review, and thank you, Mr. Bobroff, for that introduction. Before we get started on our update on new housing legislation, I want to walk through a couple quick housekeeping items. So we're planning on walking through this on a bill-by-bill basis. They're arranged around some themes, which we'll get into shortly. We'll plan on reviewing the entire slide, and then we'll pause for to allow staff input or questions from your council and decision makers. Second, we want to highlight and note that this is a high-level presentation, and we are not discussing any currently pending or anticipated housing development projects within the city at this time. So with that, I will move on to our outline here. So as I mentioned, we've kind of organized these around some central themes or issue areas. First, we'll discuss the intersection of CEQA and housing laws. These are primarily based on two major budget bill trailer bills that passed on June 30th, 2025 and took effect immediately. Second, we'll discuss various bills that increase enforcement over various California housing laws. And then third, we'll talk about various bills designed to incentivize or facilitate housing production through permit streamlining, small-scale development, or other more niche specialty housing bills. So first, we're going to talk about Assembly Bill 130. This is one of two budget trailer bills that passed in June 2025. The biggest ticket item, which I'm going to spend a few slides talking about, is a new statutory CEQA infill exemption for qualifying infill projects. This package has various site eligibility criteria and project eligibility criteria, but otherwise establishes specific deadlines for local agencies to make a determination about whether this exemption applies and then process the project if it does apply. So first, I want to talk through the site eligibility criteria at a high level, and then we'll get into some more detail here. But in order to qualify for this exemption, you would need to, your site must be smaller than 20 acres or smaller than 4 acres if it's a builder's remedy project. The project must be located within a census-designated urban area or an incorporated city. It must be surrounded by at least 75% by urban uses or on previously developed land. And it must meet 11 SB 35 criteria, which I will get into in a following slide. In terms of what the project must contain or be about, it must be consistent with all local plans. It must align with the general plan and zoning regulations. It has to meet a certain minimum housing, minimum density, which is 50% of the local density standards for low-income housing within the jurisdiction. For the city, that means greater than 10 units per acre. It must not involve the demolition of a historic structure, and it must not involve any hotel uses. So I'll pause there for any comments from staff or questions.
I have a question. So given the criteria that you had just mentioned, are there, without mentioning any specific projects, are there areas in CARP that would be affected by that particular change?
Yes, there are potential project locations, and we'll talk a little bit about more when we dig into these SB 35 criteria on the following slide, but the general consensus is that I think it's a much more narrow subset of sites than we might otherwise anticipate given our location on the Central Coast.
Got it. Thank you very much.
Yes, Commissioner Banfield.
See, how am I going to put this? Okay, so it says you have to conform to the plan, but then you have builder's remedy that doesn't. So which one do we pick?
So if it is a builder's remedy project that would otherwise qualify, the project is deemed consistent with the applicable plans and policies. So you would need to still move forward with the exemption provided it met the 4-acre size limit and met all the other site criteria. So the site criteria would still control, but you'd have to find the project consistent with the plan even if there was an inconsistency. Now there's a wrinkle here in the coastal zone with respect to policies that are embodied in our certified local coastal program, in which case that mostly untested, but there's a position that the city would try to harmonize Coastal Act policies and apply those policies to projects to ensure consistency with the Coastal Act. So,
Okay, thank you.
I have a quick question on this one. I read, I think in the, I'm pretty sure it's SB 1, the one we're talking about, right? Did this have to do also, is there a building code freeze?
Yes, I have a slide on some of the other components
Oh,
of
okay,
of it. Yeah.
I wasn't sure if you were going to move forward, or I had a question about that.
Yes.
For when you get there, thank you.
We will get there, I promise. All right, hearing no more questions, I'll dive in since I think we're already starting to talk about some of these SB 35 site eligibility criteria. So SB 35 was an older housing law that establishes a list of 11 criteria. And while this AB 130 exemption was sort of characterized broadly as applying generally in almost every urban area. I think that may be true in areas of larger cities, but in areas like the city of Carpinteria and a lot of the Central Coast, you'll see that many of our sites contain one or more of these site eligibility criteria. So, for example, the development project, in order to use AB 130, it needs to not be within a specified portion of the coastal zone. These are generally referred to as kind of the coastal appeals jurisdiction, but include things like within the coastal appeals jurisdiction, the site must not be potentially subject to 5 feet of sea level rise. It can't be on a location that's not zoned for multifamily housing, and it can't be within 100 feet of a wetland or on prime agricultural land. The site cannot contain prime farmland or farmland of statewide importance. Can't contain wetlands. Can't be within a very high fire severity zone unless it can meet certain criteria. It can't be on a hazardous waste site unless it can demonstrate cleanup compliance. Can't be within a delineated earthquake fault zone or in a special flood hazard area, regulatory floodway, within a identified in a conservation plan, or habitat for a protected species or subject to a conservation easement. So there are quite a few environmental site constraints that apply to these types of projects and eliminate them from being able to use this CEQA infill exemption. I'll pause here for questions.
How do we define prime farmland?
That is it's mapped by the USDA and the state.
Okay.
So it's
I figured it was
it has a
something
very,
very specific.
yes, it has a very specific definition,
Thanks.
as well as farmland of statewide importance.
Sure.
Can you define natural and protected land?
Yes, we have another slide on natural and protected lands coming up.
And have we received the urban infill sites map from the state?
We have not received a sites map. However, there are some common tools that are helpful in doing preliminary assessment. One is site check by, sorry, they have a new name for it, the Governor's Office of Land Use and Climate Innovation has a map that helps you evaluate whether the criteria may apply to a specific site.
All right, but in the report, you call out that the state was putting this together, the map, right?
Yes.
And then it would be submitted to the city, and the city would have ability to comment?
Yes, that submission hasn't occurred
That's
yet.
what we're talking about. All right, thank you.
Well, so I think there's an existing tool, and then there is a formal mapping requirement that needs to take place.
Maybe before we leave the CEQA exemption part of AB 130, it's helpful, I think, just to put this in some context for the city. So right now, most of our smaller housing projects, even up to a 24-unit mixed-use development project, typically qualify for a CEQA exemption already. We're already using some of the other exemptions that are allowed for under state law. And so in terms of just a kind of broad applicability across the most common types of projects we see, I don't think this is going to change anything for us drastically. There may be some limited applicability of these exemptions to larger projects that previously would not have qualified for an exemption, but I think given all the different site criteria that Mac ran through, it's going to be somewhat limited in the numbers of larger potential projects that we could see that might be able to take advantage of this exemption.
Thank you. All right. Next, I want to hit on, I think, a couple other related but ancillary components of AB 130. It amends the Permit Streamlining Act to include removal of including removal of a public notice requirement. So the Permit Streamlining Act sets forth specific deadlines that the city must meet to determine whether an application is complete and approve a project after environmental review under the California Environmental Quality Act is complete. And the Permit Streamlining Act previously had a requirement that a public meeting needed to have occurred before a permit could be deemed approved as a matter of law. So the order of operations here would be applicant submits an application, city has a deadline to respond and determine whether that application is complete or incomplete. Once that application is found complete, the city processes that application through environmental review. In some jurisdictions, they approve either typically an exemption or occasionally an environmental document. And then an agency has a certain deadline to act from that approval of the environmental document deadline. So what the legislator felt is that this bill didn't have enough teeth because what it previously had a requirement that a public meeting had to have occurred before a project could be deemed approved. So in a scenario where a local agency approved a CEQA exemption at a staff level or had a prior hearing on a project to approve an environmental document, and someone sought to use the deemed approved language, an applicant sought to use the deemed approved language, they couldn't do so because of this. They would basically have to schedule another public hearing to hear whether the project had been deemed approved or not. So the legislator removed that requirement. Generally, this is probably not going to have a major impact in the city because we closely monitor all of these deadlines and ensure that we have public hearings and that decision makers consider the projects within the applicable timeframes. We also bring determinations on the project at the same time we bring determinations on the environmental review. And so there's not any scenarios in which we have an environmental review approved and we don't have a project approved, because usually those decisions happen at the same meeting or within a short period of time. But that's a change for some jurisdictions. There's a freeze, as mentioned, as one of the commissioners mentioned earlier, that there's a freeze on state and local building code updates until June 1, 2031, subject to certain limitations that are generally around avoiding emergencies and home hardening for fire protection. And And then finally, this bill also limited the Coastal Commission appeals jurisdiction somewhat by exempting multifamily housing projects of 4 or more units that are exclusively residential from appeal to the commission if the project is located within sensitive coastal resource areas as defined in the specific government or public resources code section, or where a project was approved by a coastal county. Couple items to note is that appeals still exist near shoreline tidelands or wetlands. And I would add that the city of Carpinteria doesn't have a sensitive coastal resource area that's been identified. So there's kind of a limited range of projects that this might apply to, especially we're also not a coastal county. So the changes aren't significant really for the city in that respect. I'm happy to answer any questions or.
A question about the permit streamlining portion of it. So then that, just because the public notice requirement is no longer necessary, it doesn't preclude the city from still going through those steps, right? Because it seems the public noticing, is that part of transparency in terms of residents being aware of various steps in these processes?
So in some jurisdictions, well, yes, it would prevent
it would,
the city.
okay.
So basically, in the jurisdictions where they've missed these deadlines, for example, they made a determination on the environmental document, and then they never made never approved a project. This change to the law would allow or require the agency, if they miss that deadline, to approve their land use entitlement without a subsequent public hearing. So yeah, pretty hefty penalty, and highlights the importance of deadlines.
Thank you.
With that, I'll turn it over to my colleague, Cody Sargent, to talk through SB 131.
So like AB 130, SB 131 was passed as a trailer to the budget bill, and also makes some pretty significant amendments to California Environmental Quality Act, predominantly by providing new exemptions. The first exemption that we're going to talk about from SB 131 is the most significant from the bill, colloquially referred to as the near miss exemption or near miss streamlining. And what this provision does is it provides streamlined environmental review process for housing projects that almost qualify for a CEQA exemption, but for a single missing condition. So it almost meets the exemption, but doesn't because of one item. And in that case, if it qualified in that way, environmental review would be limited to impacts caused solely by that single disqualifying condition. And the environmental review wouldn't need to include analysis of alternatives or growth-inducing impacts, things that are typically required as part of the CEQA process. So just thought it'd be helpful. It's a hypothetical if an apartment project, an infill apartment project was proposed on a vacant parcel in an urbanized area that would otherwise, for example, qualify for a CEQA infill housing exemption, but it's disqualified because it's adjacent to a designated historic resource. Under SB 131's near miss provision, environmental review could potentially be limited only to potential impacts on that historic resource rather than requiring the full CEQA analysis. The idea from the bill just being that it would allow the project to move forward through approval more quickly while still addressing the specific environmental concern. There are, of course, quite significant limitations and exclusions on this near miss. It only applies to housing projects. It excludes projects that are dissimilar to those in the missed exemptions list, and the housing projects that include distribution centers or oil and gas facilities. It also doesn't apply to projects on natural and protected lands, which the next slide will lay out what that is defined as. And as you can imagine, there's still quite a bit of ambiguity in this bill as to what constitutes a single condition and what's the scope of the environmental review on that single condition. We anticipate that there'll be further guidance from the agency or judicial interpretation through the courts to scope out what this actually looks like in practice. I'll pause there for any questions.
Wouldn't you kind of have, if you're going to pick, how would you decide which is the single item? Or it's something that just pops out at you, or?
Councilmember Clark, in practice, I think the applicant would raise that they fall under this near miss exemption, so they would be, or the city in looking at the project would see that in its environmental review would see that the project would qualify for an exemption except for one condition. There wouldn't be choosing between different conditions because if the project didn't qualify for multiple conditions, then it would not fall under this near miss. So the near miss streamlining only applies if they miss the exemption by one condition.
Yeah, and just maybe to clarify, right, most of these exemptions list out kind of specific qualifying criteria. You have to be, X, Y, and Z. And so if you meet X and Y, but you don't meet Z, that might be a scenario where you could apply for this single issue environmental review allowed under SB 131. But if you don't meet two or more of the criteria for that exemption, then this isn't going to be a tool that you can avail yourself of.
Have we had projects that fall under this near miss category in the past?
Perhaps. There's a couple that have come to mind that dealt with archaeological resources where they were, maybe in an area that otherwise could have been fully exempt, but given that one particular sensitivity, we couldn't use the exemption and had to do a more expansive environmental review. So there might be scenarios like that it could apply to.
Got it. Thank you.
Great. And so as I mentioned, while the SB 131 near miss exemption potentially could have some broad implications, it's also still fairly restricted. The development project can't be located on a site that's a natural and protected land. It's defined as including environmentally sensitive areas within the coastal zone, within 300 feet of a wetlands, state and national park system or national recreation area or monument, wilderness or marine protected area, national wild and scenic river systems, any ecological reserve or wildlife management area, a hazardous waste site, subject to some exceptions if cleanup has been complied with, within a regulatory floodway, lands under conservation easement or protected as preserve areas within a high fire severity zone, or on prime farmland or farmland of statewide importance.
One point of clarification here. Some of these, like for example, the within a regulatory floodway and within certain high fire zones, are still permits can still be issued if you agree to abide by certain standards like finished floor heights and can demonstrate that the project would be safe or otherwise implement certain home hardening aspects of it. That said, it still triggers a lot of these exemptions, or kicks you out of some of these exemptions.
Are there any other questions on this slide? Okay, great. Moving on, SB 131 also creates several statutory CEQA exemptions for projects that the legislature deemed to be socially beneficial projects, notably child care centers, rural health clinics, food banks, farm worker housing, parks, and clean water infrastructure projects. Each of these is defined further in the bill and has some restrictions and limitations, but generally these are statutory exemptions from CEQA. SB 131 also narrows what documents must be included in the administrative record for CEQA lawsuits, the goal being to streamline CEQA litigation. And finally, the bill provides further direction to the Office of Land Use and Climate Innovation, which, as Mac Carlson mentioned, was formerly called the Office of Planning and Research, as the designated rulemaking entity to effectuate infill housing streamlining. Are there any questions?
Other than farm worker housing, this CEQA exemption, is there a link to housing in the socially beneficial projects portion of the exemption?
Commissioner Allen, no, these statutory exemptions each one of them is a specific statutory exemption. So I believe aside from farm worker housing, none of those specific statutory exemptions are housing focused, whereas the streamlining and the one included in AB 130 is more targeted at housing.
And a high level point of clarification, Commissioner Allen, many of these exemptions for some of the projects are related to statewide grant funded or bond funded projects. And so I think the intent there is to, for example, for clean water projects, if your clean water project was granted state funding by the State Water Resources Control Board, for example, the thinking is that by the state board's process of granting you that funding, they did the necessary environmental review to confirm that you're a beneficial project. And so I think that is the intent of why these were sort of included, why these were included in this otherwise more targeted to CEQA and related to housing bill. All right, if there are no further questions, we'll start into our next theme, which is increasing enforcement authority over California's housing laws. Unfortunately, I think you're going to notice that most of this theme involves additional state enforcement against local agencies. However, Cody Sargent will get to share at least one bill that gives the city more authority. We'll start with AB 712. This bill makes some changes to create sort of new causes of action to allow a housing development project applicant to seek reasonable attorney's fees and costs if a local agency violates a specific housing reform law, and it imposes more severe penalties if an agency was previously warned by the Attorney General, the California Attorney General, or the Department of Housing and Community Development, or if the agency previously violated the same state housing reform law. Housing reform laws are broadly defined in the statute to include any law that protects housing development applicants or limits a local agency's actions affecting a housing development project. It sets forth that the applicant must bring their lawsuit within 60 days of providing a specific written notice to the agency to either cease the challenged conduct or they're planning on filing notice. In instances where an individual sues and is successful, the fines and penalties that the statute authorizes must be paid to either the local housing trust fund or a statewide building, homes, and jobs trust fund. And it also prevents public agencies from requiring developers to indemnify, defend, or hold harmless the agency if the developer or the applicant sues the agency for violating a housing reform law. So happy to pause there for any questions. Hearing none, I'll move on. Go ahead.
The next bill regarding enforcement over California housing laws is AB 1308. Unlike most of the state laws that focus on the entitlements and permitting, AB 1308 targets delays that occur after construction, such as waiting for final inspections. So the bill requires now that building departments must inspect residential construction projects within 10 business days of receiving notice of completion of the permitted work. This applies only to new residential construction of no more than 10 units and residential additions to existing residential buildings if the total number of units doesn't exceed 10 units. It also clarifies that any failure to complete this inspection in that time would constitute a violation of the Housing Accountability Act. Also, just worth noting that the bill also provides that if a local agency doesn't meet this deadline, an applicant can go hire their own qualified private professional provider, such as a licensed engineer or architect, to complete the inspection. And the local jurisdiction must review the report prepared by their professional within 14 days of receipt and either approve the report or issue a correction notice. And I'll pause here for any questions.
I think for me, for most of these, I'm trying to understand which ones would be the most applicable for the city. So I'll direct this one to city staff. But are we in a situation where our normal timeline of the 10 business days for building inspection, is that something that is would potentially pose a challenge in the future, or is this one that maybe we wouldn't have to worry about as much?
Through the mayor, Vice Mayor Slarceno, this is one I'm not particularly worried about. In general, we're very responsive to requests for inspections and can get those scheduled and completed within a couple days of receiving a request. I think this is likely to be an issue for much larger municipalities that maybe have a greater backlog than we do.
Got it. Thank you very much. That's helpful.
All right, I'm going to take the next one. This one is maybe a little bit out of order, but it's related to building permits, so we slotted it in here. But AB 253 is the California Residential Private Permitting Review Act. It requires local agencies to provide an estimated time frame within which a completed housing permit application of 10 units or fewer will be reviewed for building permits. If the estimated time frame exceeds 30 days, or if within 30 days of an building permit application being deemed complete, and the local agency fails to complete the permit review, a licensed and certified third-party reviewer may provide plan checks at the expense of the applicant, and then the public agency must approve or deny the permit and with that information from the third party within 10 days of receiving that report. And so this bill is designed for these smaller 10-unit or fewer projects to allow the applicant to go out and hire a third-party building department effectively to review the plans and submit that review to the city in instances where a city has a significant backlog.
And again, just to beat you to the punch, I don't anticipate this one being a significant issue for the city either. We strive to get our first building permit plan check completed in about 2 weeks' time. And while we may not always meet that, that still gives us sufficient buffer, I think, from this 30-day deadline imposed under AB 253 that I'm not anticipating this will be too much trouble for us.
Thank you for reading my mind.
The next enforcement bill that I'll talk about is Senate Bill 786. This bill makes a number of changes to enforcement regarding housing elements. At first, the bill clarifies that the most recently adopted element in the general plan controls if there's any conflicting development standards included in the different general plan elements. So in other words, it establishes that if there are conflicts between, for example, the land use element and the most recently adopted element, which often will be the housing element, the most recently adopted element controls, aimed at removing ambiguity that could potentially delay housing projects. The bill also establishes additional consequences for local governments when they commit to but fail to meet the deadlines for removing constraints on housing development and implementing their housing element, including authorizing the California Department of Housing and Community Development, HCD, to review and potentially decertify housing elements adopted by those agencies. And finally, the bill amends judicial procedure for housing element cases when a housing element is challenged in litigation, including expediting temporary relief in certain scenarios and specifying that a court order to adopt a housing element is not stayed pending appeal of a case. And I'll pause here for any questions.
All right, hearing none, we'll move on to Senate Bill 808, Civil Actions, WRITs, Housing Development Projects. This bill expedites enforcement actions brought by project applicants or the California Attorney General challenging improper denial of a housing project application under state housing laws, including the Housing Accountability Act, any ministerial approval laws, like SB 35 or 423, as well as state accessory dwelling unit laws or ADU laws. So the bill sets forth very specific notice requirements that the petitioner must include in their petition and provide to the city before filing their lawsuit. If they include those and serve the petition within 90 days of the local agency's denial, disapproval, or conditioning of a project or permit, then much tighter litigation deadlines apply. So within 15 days of service of the writ, the local agency must prepare and certify the administrative record. That's a very short timeline. A hearing must be set no later than 45 days after the filing of a writ, and the court decision must be issued within 30 days of the matter being submitted or 75 days after the writ is filed, whichever is earlier. So this is a pretty dramatic change to an imposition on the courts in particular, in terms of the timeline that typical cases take and the priority for housing cases over other cases that might be on the court's docket. Any questions?
I have one for you, Mac. I was just curious if we've seen these new timelines invoked yet, to your knowledge, and just, if it's realistic that the courts can actually keep up with these sorts of timelines that have been put on them.
I'm not aware of a case in which these timelines have been invoked and met yet. And part of that is because we're kind of in a narrow window of when the applicant would have been able to provide the notice, right? And when their approval of the project would have had to occur. But we will almost certainly see some of these this year and have a better understanding of whether or not courts are actually able to hit these deadlines.
Great. Moving on to what I hope will be a breath of fresh air. The only bill we're summarizing on enforcement that provides the city with assistance in their enforcement. Senate Bill 346 was passed with the intent to assist local agencies' ability to enforce their restrictions on short-term rentals. Specifically, the bill authorizes a local agency to enact an ordinance requiring short-term rental facilitators, such as Airbnb, VRBO, to report physical address of each short-term rental. It also authorizes them to request additional information if the physical address isn't sufficient for the local agency to identify the specific short-term rental, and authorizes the city to impose an administrative fine or penalty for failure to file this report, and allows the local agency to initiate an audit of a short-term rental facilitator as needed. And then finally, the bill requires short-term rental facilitators in a jurisdiction that has adopted this ordinance to include in the listing of a short-term rental any applicable local license numbers associated with the rental and any TOT tax certification issued by the local agency.
I have a question about that one. I know that the city contracts with HDL for a lot of our short-term rental needs. Is that information, like getting the physical address of the short-term rentals and other information, is that included in what we contract with them for already? Or would that be something that would be updated?
Through the mayor, Vice Mayor Solarsano. So HDL is standing by and is ready to assist us with this effort. They too, like us, are still getting up to speed with this and trying to understand how this all actually is implemented and plays out. I will say that, having attended a League of California Cities webinar about this law back in December before it took effect on January 1, there was some signs that some of the online short-term rental platforms may try to challenge this law or may try to challenge whichever jurisdictions adopt this ordinance first or make the first attempt at requesting the address information. And so given that uncertainty, I think our position as staff was to take a little bit of a wait-and-see approach and see how that shakes out, with the intention of folding this required update to our ordinance in with some of the other short-term rental ordinance update work that we already have on our work plan, once we have kind of a clearer picture of whether this survives in full or in part through a legal challenge.
Okay, that makes sense. Thank you.
Can I ask a question about short-term rentals? Have we ever cited anybody?
Through the mayor, Commissioner Benefield, we have on a few occasions. We are getting more aggressive in it here in kind of last year, I'd say, in part at the direction of the city council. And one of the updates, in fact, that we hope to bring back to the council through an ordinance update to the short-term rental regulations is to increase the fine amounts for penalties. So right now, penalties are assessed on the same schedule as any other citation in the city. So $100 for the first violation, $200 for the second, $500 every time thereafter within a calendar year or a 12-month period. I couldn't tell you what the Assembly bill or Senate bill was, but under a state law passed several years ago, those fine amounts were increased substantially to where the first violation was maybe more like $1,000, and then it went up from there quite a bit, with the belief that those much larger fine amounts would be much more persuasive in eliminating illicit short-term rental behavior.
Yeah, it might be a good way to make money for the city to cite these people and make housing for real people. Sorry, opinion.
Any other questions? Hearing none, we'll move on to a couple bills that either streamline or clarify certain aspects of the permit process. The first one I want to touch on is some changes to state density bonus law. As a reminder, state density bonus law grants qualifying projects certain benefits, including a bonus density, incentives or concessions, waivers or reduction of development standards, and specified parking ratios when the project agrees to deed restrict a certain percentage of the units as affordable to either very low, or moderate income households. Two bills were passed this year seeking to address some specific density bonus law issues where an applicant was leveraging density bonus law generally for a hotel use. And so those two bills specified that certain provisions of density bonus law, for example, incentives or concessions or waivers or reductions of development standards, do not apply to standards related to transient lodging that are part of a housing development project unless it's a residential hotel. And then in order for residential portions of a mixed-use project to qualify for density bonus law incentives, at least 2/3 of the square footage of the project must be residential. So these are very beneficial changes to make sure that density bonus law isn't abused to promote hotel-type uses. Any questions?
I have a question on that one, or maybe clarification. Can a builder apply for density bonus and builder's remedy at the same time? Or can there be a requirement, like up front, that we know, are they going for both? If they're only going for one, and then maybe there's a wait and see, or, I guess I'm concerned about leverage that this gives developers over the city to use it that way. Does that make sense?
Through the mayor, Commissioner Van Antwerp, let me try to answer, and hopefully, if I don't capture your answer your question, feel free to follow up. So yes, an applicant for a housing development project can use multiple housing laws to promote in their project. So that could include some of the laws we've talked about this evening, Permit Streamlining Act, for example, that generally applies to all development projects, both housing projects and non-housing projects. You would also look at using the Housing Accountability Act. So the Housing Accountability Act would apply to a certain subset of projects. A smaller subset of projects may qualify for the so-called builder's remedy within the Housing Accountability Act. Those projects could also, to the extent they need to or want to rely on density bonus law, could argue that density bonus law also applies to their project. So in short, yes, an applicant can leverage multiple state housing laws for one specific project. The findings and decision about whether those laws are applicable typically comes at when the law is before either your planning commission or the city council on appeal. And so staff evaluates whether or not a project meets the qualifying criteria for example, density bonus law throughout the entitlement process and makes a recommendation to your commission and then the council on appeal on whether the project complies or does not comply with the applicable requirements.
Okay, the city can't require the developer to elect one pathway before the hearing. Is that correct?
Correct.
Thank you.
Moving on.
The next bill is AB 1007. This bill amends the Permit Streamlining Act. Just as a reminder, Permit Streamlining Act is existing law that requires public agencies to approve or disapprove a development project within specified time periods. The Permit Streamlining Act currently requires that a public agency that serves as a responsible agency for a development project under CEQA must approve or disapprove the project within 90 days of the date that the lead agency approved the project. This bill reduces that time amount from 90 to 45 days for the responsible agency. Just as a reminder, CEQA responsible agency is a public agency other than the lead agency that still has jurisdiction over a project. So for the city, while the city typically sits as a lead agency, they could be a responsible agency if, for instance, the city was required to approve a permit for a county-led project. I'll pause for any questions.
All right, hearing none, we'll move on to Assembly Bill 1050, which deals with unlawfully restricted covenants for housing developments. AB 1050 extends prior bill Assembly Bill 721, which created a covenant modification pathway for 100% affordable projects. And so this AB 1050 expands that to any qualifying or any housing development project on a commercial property where the commercial property is generally an allowed use or could move forward. But there's a private covenant or deed restriction or reciprocal easement that would limit residential use density or unit counts. And so often where you see these is for large-scale mall redevelopment projects. So it's very common in the 50s through the 70s for every major mall when they to have kind of major tenant anchors and reciprocal easements with all of the businesses in the mall, that parking was a mandatory use for basically their entire parking lot. And so where we see changes, and then I guess often those parking lots were then either dedicated to a local agency or held within an HOA. And so where we're seeing the legislature try to tackle here is preventing those covenants that restrict redevelopment of parking lots, for example, into housing from a commercial use. And so this removes or creates a process where a property owner can invalidate those restrictive covenants and move forward with a residential conversion project. Any questions?
I have a quick question. Are there any, well, would that also, is that also business parks that aren't being used?
Sure. If a business park, for example, had a covenant that said no, there's no allowable residential use within this business park, that this may be an avenue to remove those covenants.
Thank you.
Moving along, SB 358 amends the Mitigation Fee Act and mandates that there be reduced traffic impact fees for housing development projects that adhere to specific criteria, that they're located in a transit priority area, which in City of Carpinteria is within 1/2 mile of a major transit stop, which is the Amtrak station, that they provide no more than one parking space for 0 to 2 bedroom unit projects or 2 spaces for 3 or more bedroom units, and they be within 1/2 mile of 3 or more specified amenities such as a grocery store, pharmacy, or public library. So if the project meets those criteria, the bill mandates that there be reduced traffic impact fees for the project. It also requires that local agencies make certain findings supported by substantial evidence to adjust, increase that traffic impact fee. Any questions?
Is it residential?
Correct.
Yeah.
All right, moving on. We're going to move on to kind of a next theme of focusing on small scale development. In the next 4 slides, we're going to cover various changes to state accessory dwelling unit or ADU and junior accessory dwelling unit or JADU laws at a high level. Quick update from the city side, and perhaps Mr. Bovroff can provide more details. But the city is presently working with the Department of Housing and Community Development as well as the Coastal Commission to finalize some revisions to its accessory dwelling unit ordinance and junior accessory dwelling unit ordinance to harmonize it with these latest changes to state law while still protecting coastal resources. Staff in our office are tentatively anticipating bringing these amendments back to decision makers sometime this summer. So this is a little preview of what you'll probably get more detail about when we bring back those amendments. The first bill here I'm going to cover is AB 1154. This makes a couple minor changes to requirements for junior accessory dwelling unit ordinances. It explains that owner occupancy is not required if there's a separate sanitation facilities. So if there's a separate bathroom facility, then owner occupancy isn't required for a home that has a junior accessory dwelling unit. And it clarifies that any rental of a junior accessory dwelling unit must be for more than 30 days. So that obviously junior accessory dwelling units can't also be short-term rentals. And that's was already reflected in state ADU laws, but it's been clarified for junior accessory dwelling units as well. Any questions here?
The next bill that we're going to talk about that amended state ADU law is AB 462. It makes further amendments to state ADU law. Existing law requires that certain ADUs proposed in coastal areas are required to obtain CDPs in addition to other local ADU permit requirements. And AB 462 alters the CDP status quo on numerous fronts. First, it requires that local agencies with a certified LCP must approve or deny a completed CDP application for an ADU within 60 days. It eliminates the ability to appeal a CDP to the Coastal Commission for an ADU. And historically, state law prohibited a local agency from issuing a certificate of occupancy for an ADU before one was issued for the primary dwelling. And AB 462 creates a narrow exception for ADUs when the governor has declared a state emergency, the primary dwelling was substantially damaged or destroyed by an event referenced in that state of emergency, and the ADU has been issued construction permits and passed all required inspections. Just as some context, this was initially intended to help recovery efforts after the Eaton and Pacific Palisades fire, but it could apply to other state of emergencies going forward. Any questions?
I'll just add, we already process our coastal development permit applications for ADUs within 60 days, so this won't change anything for us.
Moving right along then to SB 9, accessory dwelling units ordinances. This bill establishes a process or more firmly requires local agencies to submit ADU ordinances to the Department of Housing and Community Development within 60 days after adoption, or because it would otherwise invalidate that ADU ordinance if the agency fails to submit it within that 60-day period, or otherwise fails to respond within 30 days to a finding that the ordinance is not in compliance with state ADU law. As I noted earlier, the city will coordinate and has been coordinating with the Department of Housing and Community Development and the Coastal Commission as part of its local coastal program amendment to implement, update its ADU ordinance to more accurately reflect changes to state law that since the last time we updated. Any questions here?
The next bill that's amending ADU law, Senate Bill 543, primarily focuses on clarifying and codifying existing HCD guidance that is regarding ADUs and JADUs. It specifies that statutory references to square footage in an ADU or JADU refers to the square footage of the interior livable space. It expands authority of HCD regarding JADUs to mirror the authority that HCD currently has over ADUs. And state ADU and JADU standards, it clarifies that those standards supersede conflicting local ordinances. And finally, if JADU ordinances are void, if the local agency fails to submit to HCD or fails to correct non-compliant identified by HCD.
Could you explain interior living space?
Through the chair, Commissioner Moyer, historically there was some ambiguity in state ADU law as to how allowable square footage was calculated and whether it include, for instance, outdoor patio space or other areas that could potentially constitute allowable square footage. And here HCD issued guidance that clarified that in calculating the square footage for an ADU or JADU, it was the livable space inside the ADU or JADU, and this bill is codifying that HCD guidance.
So it's excluding the interior partitions?
No,
No.
I don't believe so.
So
I
it's
believe
like net.
correct. It basically is excluding things like the thickness of exterior walls, exterior stairways, roof overhangs,
Correct.
carports, porches, that kind of stuff. But anything enclosed within the building, even hallways and that sort of stuff count still towards that interior livable area figure.
Thank you.
Just one Nick, do we have any JDUs here in this town?
We do have a couple. We don't see a lot of them, in part because there's not much distinction between a JADU and just a small ADU. So most folks just tend to go for the ADU instead. But we do have a few.
Thank you.
The primary difference is a JADU has to be carved out of the existing square footage of a home. And also, I believe a JADU doesn't have to have all the same amenities, so it can have shared cooking facilities or shared sanitation facilities with the primary house. Whereas an ADU has to be standalone in those respects.
It can be a converted garage.
Correct. So it could be, again, the JADU has to be carved out of existing square footage, whereas an ADU could be a brand new standalone structure, for example.
Thank you.
There's also square footage limitations to a JADU. I don't think it can be larger than 500 square feet, I believe.
Continuing on with Senate Bill 543, a few other changes that the bill implemented. It clarified that development impact fees can't be imposed on ADUs with up to 750 square feet of, again, interior livable space, or JADUs with up to 500 square feet. Similarly, ADUs and JADUs with 500 square feet or less are also exempt from school impact fees. And finally, the 4 categories of ADUs or JADUs that are specified in the government code, and those are attached or detached ADUs to a single family or attached or detached ADUs to a multifamily dwelling. This bill clarifies that those 4 categories can be combined on a single lot and aren't exclusive, so more than one category could be applied. And finally, it outlines a permitting process requirements for local agencies. Finally, SB 543 clarifies that amendments don't take effect in the city until it amends its LCP to harmonize the LCP with the amendments relating to ADUs and JDUs.
So just clarification on the 4 categories can be combined now. So for our single-family residential neighborhoods that I think under our current ordinance would be limited to an ADU or a JADU, but not both. Does this now allow both on a single-family residential zone?
Through the mayor, Commissioner Lefevers, that's our understanding, is that theoretically, right, a single-family residence owner could have a attached ADU, a JADU, and or a detached ADU. So conceivably, you could have up to 3 different types of ADUs on a single-family lot in addition to the primary residence.
They could do a subdivision and add another resident and an ADU on the subdivided part.
If you're referring to the SB 9 lot splits, there are provisions where you can subdivide a single-family lot into separate lots and then build new units on each of those, including some number of ADUs. So yeah, it can quickly multiply.
And through the mayor, Commissioner Lefevers, just one point of clarification. The city expects to, based on Coastal Commission guidance, that these changes will be brought back to your commission for consideration into the ordinance through an LCP amendment. But until that local coastal program amendment happens, these laws don't take effect immediately. That's based on some prior Coastal Commission guidance that said local agencies should adopt an ADU ordinance that complies with state law, but it doesn't take effect until they get a certification of that local coastal program amendment. So the city's position has been, we're going to update to comply to the extent we can, and while being protective of coastal resource.
Is there a regulatory clock on that?
There's, as kind of outlined earlier, there's potential, let's say, inquiries from the Department of Housing and Community Development and Attorney General's office that could occur. And there's also, I think, a timeline specified in the city's housing element. So we are working with staff to move that ordinance forward as soon as feasible.
Thank you.
Are there any other questions before we move on? All right, we got a little bit of a preview about this one, but because of the mention of Senate Bill 9, which is a duplex and lot split bill, AB 1061 was a fairly minor amendment to Senate Bill 9 that clarified that these projects can be approved in historic districts as long as the development doesn't alter or demolish an existing historic structure. It also specifies that local agencies can adopt objective standards to preserve local character in order to ensure that any Senate Bill 9 project in a historic district doesn't negatively impact a historic resource. Again, this is one of the bills that the Coastal Commission has generally opined that do not take effect until the city updates its ordinance or its local coastal program to implement. I'd also note that I do not believe that the city has any historic districts currently. So Mr. Bobroff can confirm, but.
You're correct.
All right. Any other questions on this one? All right, we'll transition to a couple very specialized housing bills, and we'll wrap up with general questions at the end, so we're getting very close.
All right, moving on from state ADU, the first of the two specialty housing bills, excuse me, is AB 1021. This bill extended the sunset date of existing law, AB 2295. It was originally set to expire on January 1, 2033, and that bill allows for local educational agencies, such as school districts or County Office of Education, to develop affordable housing on school district property, provided that certain conditions are met. AB 1021 extended the sunset date for another 3 years to January 1, 2036, as well as made some revisions to further streamline the approval process, clarifying that the Housing Accountability Act applies to these projects, and as well as the affordable housing projects on school district property could qualify for applicable affordable housing CEQA exemptions if they meet those criteria. Pause for any questions on this bill.
Was there any consideration to making school district properties for affordable housing, giving first right of refusal to teachers and staff? Somewhere along the line, I thought we had a law like that in the state.
Through the mayor, Commissioner Benefield, I don't know offhand whether AB 2295 included a first right of refusal, but I will take a look and get back to you. I don't believe that it does have a first right of refusal, but I will confirm.
Thank you.
All right, any other questions on this one? All right, moving on, last but not least. AB 507 is one of these specialty housing bills related to adaptive reuse projects. It requires local agencies to permit by right adaptive reuse projects that allow for the conversion of existing commercial and industrial buildings to residential or mixed use, where qualifying projects can meet certain affordability requirements and labor standards. So for rental housing projects, the project needs to have 8% very low income. I think there's a typo there. And then, or 5% extremely low income units, or plus 5% extremely low income units, or 15% lower income units. For owner occupied, it needs to be 30% of the units need to be affordable to moderate income households, or 15% for very low income households. Adaptive reuse projects generally must be in buildings that are less than 50 years old, or if older, comply with historic preservation standards in order to qualify for ministerial review. And local agencies may create an adaptive reuse investment incentive fund beginning in next fiscal year in order to help fund these types of projects. There are many other qualifying criteria for these types of projects. My impression is that this is generally designed to convert large-scale buildings in San Francisco, Los Angeles, San Diego, and that these types of projects wouldn't apply in much smaller jurisdictions. But the city may, of course, see one of the type of these projects. Any questions on AB 507? If not, I know that was a long presentation and a lot to digest, but if there are any other questions, we're here to answer them.
Quick question I have. I'm jumping back to AB 1021. It's very specific in that it is a public entity education system. Are there any provisions or, I would say, challenges being met for private schools? For example, if it's a private school, if it's a church or anything like that, are those also going to be addressed, or is that just something that's going to fall through a standard process?
Through the mayor, I'll take a stab at this one, and then maybe Mr. Sargent can chime in. My recollection is that there are a few other bills that focused on housing projects for private schools, essentially, that allowed for projects to move forward on those schools, but have on those school grounds. And I believe it also applied to certain church facilities or religious institutions as well. They do not have the same level of streamlining that this bill has, is my understanding.
And then the other question I would have are programs set up by the county. That would be, for example, a preschool, something like that. Would those also fall within this, or the AB 1021, or would that be something different?
I believe so. I believe it could qualify. It would depend. It'd have to meet all the site criteria and the other requirements. Yeah.
Just through the mayor, Commissioner Benefield, to address your earlier question, I stand corrected. The existing law does include a right of first refusal for teacher and school employees.
A couple of questions I had. So one of the questions I've been getting a lot just in the past couple of months from residents is what the role of city community development staff is when projects are coming to the city. And just given like all the new legislation that we just heard about right now, there's a lot of moving pieces, there's a lot of nuance to it. So maybe just for anyone who might be listening in the public, like, I don't know if maybe Nick, if you can talk about what CDD staff's role is in the development process. When a developer comes with a project, what are staff, what does that look like for city staff?
Through the mayor, council member, or vice mayor Solarsino. I'd be happy to try to take a stab at this one, and maybe Mac or Cody might have some thoughts as well. I think typically when a project is submitted to the city, I think of staff's job as being to help review those projects for consistency with applicable city policies and regulations, and where a project doesn't conform or align, our job is to try to help steer those projects in a better direction, to a point ideally, right, where they do meet the applicable standards and criteria and can hopefully move forward towards approval. There are times when an applicant's vision for a project and the city's vision for a project or for a particular area of town don't align. And sometimes those do end up resulting in recommendations for denial. But more often than not, we find that developers are interested in making a project that works and that's successful, and are willing to make changes to their project or concession to get it to a place where it can be supported. That dynamic's changing a little bit, more and more each year in terms of housing projects in particular, given the legislature's regular attempts to restrain or limit local agency discretion. And so there are more of these instances now than there used to be where an applicant or developer may avail themselves of some of these incentives or provisions that are allowed for under state law to get something, beyond what they would have previously, or to, advocate for a project maybe that isn't, quite what we wanted. And so in those circumstances, we do still try to work towards making the project the best project that we can, but there are limits in what we can do, and they're getting to be more and more constraining each year as more of these laws take effect. And so in that regard, then, our job ends up being to still work towards the best project we get, with the knowledge that, to some degree, our hands may be tied.
I appreciate that, because I think just based on conversations I've had with constituents and people in the community, there's the perception that maybe staff have the ability to stop a project, or that the relationship between staff and developers is either hand in glove or else should be oppositional. And it's in my experience now, being on council for a couple of years, I know that neither of those extremes are the case. And so I'm hoping that we can get the message out to the public more on what CDD staff do and what their limitations, like you're saying, are, especially in the context of all these new state housing laws.
Yeah, I appreciate that, and I would welcome the help in that regard. We have an obligation to follow due process, right, and to ensure that applicants have, kind of a fair and predictable pathway to follow. We can't necessarily guarantee the outcome, but we at least need to be objective and fair in how we review their applications and take them through the requisite steps of project review. And so that's what we strive to do. And like I said, there are projects where we can push back more, or try to steer them in another direction. And there's other instances where we're constrained by either state or federal law in terms of how much we can push back.
And then my only other question, and my last question related to that also, is, so what do you see as some of the limited ways that we are able to have control, again, given this new wave of state control over local housing jurisdiction? What ways do you see it as the city as being empowered to make an impact?
More and more so, it seems like the best tool that we have is to adopt ordinances and regulations that have greater specificity and more objective metrics or objective standards. That seems to be the direction that the state is heading in and pushing jurisdictions to go in, right? So as to kind of move away from these subjective policies or subjective regulations that different people can interpret in different ways, and through replacing those standards with more objective, measurable standards, it gives an applicant a clearer roadmap from the get-go of what they need to do, how they need to design their project to be found consistent with applicable regulations. So I see that as being kind of our, probably our most important area that we need to make some progress in the coming years to be able to retain some level of control over these future development projects.
And then I know that's somewhere on our work plan too, right? The development of objective design standards.
It is.
Yes.
It's right. I think it's technically on the on-deck circle of the work plan, because it's a multi-year effort.
Okay,
it's not something that we're going to be able to wrap up here in these initial 2 years.
Okay, great. Thank you very much for the information.
Just for the benefit of the public, as you had stated, you've been inundated by questions. Almost all developers hire a planner. That planner sits down and explains all the relevant laws and lets them know what they can and can't do. So they don't come to the city blind. They know what's going on. So, and it's not something the city's doing. So anyway, I just thought I'd add that.
I have a quick question. Following up, these are questions that I'm getting asked. When I say I'm coming to get a housing law update, a question that I get asked constantly is, so does this mean that anybody that has a project in the pipes can rely on these housing laws, or is there a rule that sort of locks in what laws apply to what project? is it based on when their project is received by the city? Is it when the project is deemed complete? Is there sort of a timeline when these laws apply to what projects?
Through the mayor, councilmember mayor, yes, there are various laws that apply and to housing projects and freeze the applicable standards. One law, for example, is Senate Bill 330, which was, or often referred to as Senate Bill 330. It created a preliminary application process, and so that is a abbreviated 17-item application that allows project proponent to submit that preliminary application and freeze the applicable standards. There are other, not all applicants need to submit those applications or choose to. So another date, for example, would be when their application is determined to be complete. The application for a housing project is then evaluated against the standards that are in effect at the date their application is determined to be complete. There is flexibility in terms of applicants generally opting into later inactive standards if they choose to. But once they have and preserve a complete application, city staff's role and the decision maker's role when it comes to them is to evaluate it based on the standards that existed at the time of that they basically froze their application submittal.
Thank you.
I have a quick question, sorry. Getting back to AB 507, I think council told us that it really applies to more metropolitan areas like San Francisco Bay Area, stuff like that. Is there anything, any areas here in Carpinteria? I'm thinking of the commercial, industrial buildings area like that. Yeah.
Through the mayor, Commissioner Van Antwerp, yes, it's difficult in the abstract. I mean, I could look at this bill. Let me see. I'll send it to the printer. It's about 15 pages probably of criteria to qualify. So it's difficult for me to say yes or no without looking at all the checklist criteria. But in theory, yes, if an applicant proposed a project under that bill for a qualifying site, there's no exemption for it to be in the coastal zone, for example.
I just add that, based off the preliminary kind of summary version, I was initially excited about it, thinking, gosh, this could be a great tool for the city and in certain areas of our town where we were hoping to see some adaptive reuse type projects. But, to Mac's point, right, sometimes these bills, especially in their initial first couple iterations, end up having a lot of criteria that need to be met. And then, at least from what we've seen in past instances, the legislature ends up, kind of paring those down over time to make them more broadly applicable to a wider variety of projects. So we could see that here, but we just have to, kind of wait and see.
And I would clarify, sorry, 12 pages worth of text to review to determine qualifying criteria. I guess the other component I would add, right, is that City of Santa Barbara, for example, adopted an adaptive reuse ordinance that is more permissive than this ordinance, and should decision makers or the public be interested in that, that's something, right? Often state law sets a floor, and local agencies could choose to do more if they want to incentivize certain types of projects, so.
If I could, I have a couple questions that are more generic in nature, I guess. So are you seeing yet, or do you have an expectation that the legislature is starting to slow down on new legislation that, to remove our local authorities? Are we seeing that yet? Some of these seem like they're tweaks to legislation that's been passed. I know previous years we've had some pretty big hits. There's a few here, but I don't know. I'm just curious if we're reaching a more manageable state. Any thoughts?
Through the mayor, I am by no means a very good prognosticator here, but I can take a guess. I'd say that there's most likely still going to be some changes to housing law this year. My general understanding is that I think there's maybe a push to move towards addressing more for sale products, so condo defect reform potentially, and encouraging more middle income housing type development, so smaller type workforce housing development for sale projects. Frankly, it'll be an interesting year with the governor's race, kind of mid cycle. So I don't know if it'll be a big boon year for housing law updates or a whimper, but there's always going to be something, I think.
Okay. I know that's a hard question to answer, but be nice if we could take a little bit of a break here.
I will just add that included in the city council's agenda, I think for most meetings, is a legislative update that's prepared generally by the California League of Cities or Cal Cities Department, that outlines key housing bills that are being proposed this year. So that's a good place to look for more information on what may get enacted this year.
Okay, thanks. And then one last question, and again, I'm not sure if you have anything you want to comment on this, but do you have any thoughts, any information on, the builder's remedy process that's out there? Are builders having success using that across the state to get projects approved? Has it matured enough where you've seen court cases that have? I'm just curious. I know the builder's remedy threat is somewhat daunting, and just curious what the reality is with people actually using that in the state.
Through the mayor, Commissioner LaFevers, yes, there are many builders remedy projects kind of throughout the state at various stages of the process. I think we have seen a mixed bag, or not a ton of projects that have broken ground yet, but there are certainly projects that are working their way through either the courts or through local agencies during an entitlement process, or have already settled a lawsuit and are on their path towards approval. So I'd say it's still difficult to predict exactly how pervasive these projects might be, or how many of these projects may be built or approved or move forward. But there are certainly many that are doing so throughout the state.
Okay. All right. Thank you.
I think Board Member Wolf was trying to get in a question there too. I want to make sure we acknowledge her and give her a chance.
Obviously, I'm new to this, and so this seems like it's to the advantage, all of these are to the advantage of the developers, and really are going to nail any local planning departments, especially if they're understaffed. And if they are understaffed and they can't meet the deadlines, and they're fined, and there's a penalty, who's paying that money? Is there a budget in cities to be able to support a fine because the group is understaffed to keep up with the agenda items that come in? And so who's really fining who? So if they're fining the local agency, that money, the fine goes to a state organization, I guess, and then that money is again redistributed to local city councils or whatever. So I just don't really understand who's benefiting from all these fines and if this really is going to work. Because so often planning departments are understaffed and they can't keep up with these deadlines, especially with some of these new rules. So I just wonder how does this really work? And when you were talking about things changing if they don't actually, if some of these amendments don't really seem to work? Who's going to have taken the hit by the time they figure out that these bills need to be changed? Are we going to have a load of fines? Anyway, it's just about all these fines. It's crazy and scary for a planning department.
Through the mayor, Board Member Wolf. Yes, so I guess a couple points of clarification. Staff in our office work diligently to process and meet all the applicable deadlines when a new project application comes in. The fine component has specific triggers, right? So generally, it's you would have to have been found guilty or settle a lawsuit over a violation of an applicable housing law. Those penalties are then either those fines that would be imposed. The city would take them out of a budget fund, and they would put it into either a local affordable housing trust fund or a statewide affordable housing trust fund. And then that affordable housing trust fund would then, on the local side of things, would allocate it to a local affordable housing project. So to the extent that there is concern over understaffing, I think we are doing, staff in our office is doing everything we can to process housing development projects in a timely manner and achieve all deadlines. But yes, there is a legislative policy direction to put a stick out there to penalize local agencies that fail to meet certain housing or qualify or perform under certain housing reform laws that they believe needs to then be allocated to local affordable housing or statewide affordable housing.
Got a few questions here for you. First one, we talk about the timing of these reviews. Question for staff, Nick, if you wouldn't mind. I know in the past we've had to use consultants because we've been backlogged substantially. If these housing efforts move forward and the state is more successful in pushing the developers into doing these things, do you see us having a shortage or still being able to keep in-house these reviews specifically for Carpinteria?
Through the mayor, Councilmember Nomura. So we do currently use consultants to varying degrees on some of these projects. So for example, any project that requires a more substantial level of environmental review, whether it's a negative declaration or an environmental impact report, we're farming those out to consultants just because, right, the workload and the technical knowledge needed to prepare those is immense, and it would take up too much of our time. So that's an example of where we're already leveraging, consultant resources to help us. We have in the past, from time to time, brought on, extra help type planning staff to help us through a tough spot or through a particularly busy period. And I can't rule out that we might be in that situation again at some point in the future. And we certainly talk about it internally from time to time. And, I guess the benefit of it, right, is we could structure it in such a way that that extra help would only be working on projects with billable time back to an applicant. And so it could be theoretically at least set up in a way where it's not costing the city anything out of pocket to bring on this extra help staff.
Right. My question or concern mostly has to do with the consultants themselves. Since it goes to a consultant, it may be out of our hands. If there's an overload to the product, the consultants, they may be backlogged, and it would be out of our control as far as timing and getting these things done in due diligence if it's in somebody else's hands.
Yeah, so I think in that regard, part of what we can do or should do is not, not overload one consultant with all of these types of projects, right? So again, taking the example of an environmental impact report, we wouldn't want to necessarily contract with one firm to prepare all of our EIRs. Instead, we're going to, put each of those EIRs out for its own bid and select whoever the best consultant team is for each of those projects. And then it's, the assigned planner's job to make sure that those consultants stay on target and on schedule for their respective projects that they've been contracted for.
So you would be comfortable with that then, anticipating
I mean,
if they get overloaded?
we're doing that to a point currently. It is what it is. It can certainly get busy.
Yeah.
But there are times where we have multiple contracts out for multiple environmental documents at the same time.
Okay.
And we just have to, make sure we're allocating our time and energy in such a way that we can keep all those moving.
And thank you for the answers on that one. It sounds like we're fairly confident. I guess it will be out of our hands if we do get overloaded. Question then for council, that would be you there, Mac. The League of California Cities, the coastal counties, they seem to be a pretty a good resource for us for information coming down, specifically on actions and things like this that are happening at the state level. Have we tried to connect with them in greater extent, specifically for this housing element, to see if, in fact, we could start comparing notes, making sure that we have items, issues that may have been faced by other municipalities, to where we have answers from them also? In other words, have a proven product, something on the way of success factors.
Through the mayor, Councilmember Nomura, yes, we coordinate and review and look at what other coastal jurisdictions are doing with respect to their housing element implementation regularly. And then I would also say that I believe there's a coastal city attorneys group that meets fairly regularly and coordinates on various issues from time to time. And Mr. Bobroff, I think, can speak to their coordination on the planning side. Coordination with other coastal cities on LCP implementation and housing law.
Yeah, so we definitely do some of that. I don't know that we're currently part of any formal effort to do it, but we do it informally with our neighbors on a regular basis, where we're comparing notes on, how they're approaching certain issues and what's working for them or what's worked for us in the past.
The reason I brought that one up, it seems to be that would be a good resource and information that maybe you want to share with the different governing bodies we have here represented, to make sure that we have the latest information, those things that are working well and those things that we better be on the lookout for. Thanks, Nick. Didn't mean to put more on your plate, but looks like this may be an overload anyways if it goes through quickly.
I have one last question about AB 2295. Because it's a local, it's school district, so public property, theoretically, are there any levers that communities have to sort of get a school district to work with you, or is this at their discretion?
Through the mayor,
Sorry.
Councilmember Mayor.
It's a little wild, but just curious.
I think they're maybe beyond the scope of this discussion, but there are probably mechanisms that this city or public could leverage to encourage school district to implement a project like this. I guess I could speak broadly that I'm aware of at least a few of these projects moving forward throughout Santa Barbara County and in Ventura County, where those local school districts are put out a request for proposal for teacher housing on their property with a private partner. So it's happening, but there are various, I think, political mechanisms to encourage the local school district to do so if those wanted to be used, but there's no legal mechanism in these bills.
And through the mayor, if I could just add, I think as Mr. Carlson mentioned earlier, state law often provides the floor, but certainly the city can, through ordinance, adopt additional incentives, as for example, the city of Santa Barbara did with adaptive reuse. There could, in theory, be ordinances that incentivize certain types of affordable housing production on school sites.
have a question. So it's very clear that there's some stringent consequences if municipalities don't meet certain deadlines for approval or review. What does this look like for on the developer's side if we're working with, or if a developer submits an application, they potentially miss deadlines on their end? What kind of discretion do cities have?
Mayor Alarcon, generally a lot of these laws also include deadlines on the applicant, and then the city has its own processing procedures and rules that require kind of regular resubmittals. Those can be punitive on the applicant if they fail to move forward with their project in a timely manner, right? And that's to preserve local resources. So, for example, I mentioned the preliminary application requirement component earlier that has deadlines on an applicant to. So, for example, if you submitted an applicant submitted a preliminary application, they then have 180 days to submit a development application. They fail to do so, their preliminary application that froze the applicable standards goes away, right? And then they also have an obligation to resubmit within 90 days every time the city responds to them with an incomplete letter. So there are obligations there are state law obligations on applicants, and then the city's own code and procedures generally has a requirement that an applicant keep a project alive by resubmitting or providing information within about 90 days, or the city will typically reach out and close their application if they're not making progress, to preserve staff resources and municipal resources.
Great. And then one other question. Nick, you mentioned earlier, and Vice Mayor asked this question in terms of just how, when a developer submits an application, we don't necessarily have the onus. We can't say no. We have to work, or the city works with the developer and their planner in a way that's unbiased to review potential criteria. And I know you had mentioned in terms of the idea is to work with the developer in a way where not sway them into maybe what conform with standards. But I think my question is up to what point, right? I'm hearing all of these housing laws, how much, how little we have as a municipality with our own laws. So how much, I guess I want to ensure that there's a balance, right? Given how busy the CDD department is, how much of our time and effort is spent trying to support a developer to conform to our standards, and how much of that is like kind of organically done when it goes to like the hearing or the next step in the process where it's either ARB or planning who's diving into the criteria itself. Sorry, that was probably a loaded question, but I'm just.
I appreciate it. It's a good one. It's a good question here. Okay, so I guess I have a few initial thoughts here. To some degree, this happens with every project, and I think we're seeing, because of some of these changes in state laws, particularly as it relates to housing projects, that you're seeing more of this work being front-loaded, if you will, through staff at kind of a staff level, because of some of the limitations that have been placed on jurisdictions. So, for example, right, most of these housing projects now are limited to a maximum of 5 public hearings. And so what we used to maybe try to solve over a series of meetings with the Architecture Review Board, now maybe we're limited to 1 or 2 hearings to try to solve these issues. And so because of that, staff spending more time up front trying to fix as many of these issues and solve as much of this and make this project as best we can before we ever even let it get to a hearing, because we don't want to waste those hearings on numerous continuances or numerous iterations of the same project. So it is, I think, perhaps unintentionally becoming more labor intensive on staff up front, front loaded, if you will. I also think that, and this was, I think, part of your question, right, is how much discretion do we have, or at what point can we say, no, this project doesn't work for the city? And I think that depends on a case-by-case basis, depending on which laws are being applied or in which manner. So in some cases, we, at least in theory, could still say, no, this project's inconsistent with X, Y, and Z of our certified local coastal program, which at least for the time being continues to give us, on paper, at least some amount of protection. That, could be a tool to push back on a project. In other cases, we might be limited more narrowly to health and safety type issues, and maybe with a very high bar for, kind of demonstrating that there is a true health and safety type issue. I think in general, we don't want to be put in a situation where we would need to be recommending denial of a project and only relying on one narrow set of criteria or one issue area. I think, right, if we were, forced into that kind of situation, we'd much rather to be able to cite a variety of different criteria for why this project can't be supported. It doesn't have, it has major health and safety issues that rise to that level of significance that are necessary to satisfy state law, and it's inconsistent with these key provisions of our local coastal program and the Coastal Act. Something like that, I think, puts the city in a stronger position. But again, right, that's still risky given kind of the uncertainty of some of these newer housing laws and how they've been decided by the courts. And so, I think wherever we can, we're going to really try to avoid ending up in that scenario and keep pushing and working on an applicant towards refining a project to a place where we can find it to be consistent. And maybe Mac or Cody might have more to weigh in there, but it's definitely tricky.
I think the one piece I would add is that, say it's a very narrow subset or almost no scenario in which staff is going to be a final decision maker on a large project. So, right, to Nick's point, the process becomes more front-loaded based on the deadlines that are imposed on the city under state housing law generally. But that being said, ultimately, if staff and the applicant could not come to an agreement about what a project would need to change to be found consistent or inconsistent and to have a staff recommendation to support, ultimately, your planning commission, architectural board and review, et cetera, are going to be reviewing that development application and deciding whether or not it complies with the standards or whether or not staff's findings are sufficient to approve or deny the project, right? And so you all will have discretion to agree or disagree with staff and their recommendations, subject to the limits imposed by state housing law, right, and the risks associated with that. That being said, I guess the main point I wanted to make there is that, right, in a scenario that Nick's describing where staff is doing a lot of time front-loading and working with an applicant to try to get a better project, they don't have discretion to tell the applicant to withdraw their application or that they're not going to bring it to a decision maker. That's not within their purview. They don't have a final decision-making authority there, nor do they generally have the authority absent a deemed approved scenario to approve a project, or I guess a very specific framework in which staff processes a project that meets a bunch of qualifying criteria. That's referred to like a use by right or a ministerial project. So like AB 507 was an example, right? If that is supposed to be intended to be a checklist style project where someone would come in, we would review against the 12 pages I talked about and say, did you meet all 12 pages of these texts? And that could be approved at the staff level for that type of project. And state law is creating more categories of those projects every year. But generally, those are rarer than sort of the more traditional development review process that staff doesn't have final decision making over.
Thank you. I appreciate your responses. Do we have any additional questions for staff? Seeing none, I will open up public comment. I do not have any public comment speaker slips. Do we have anyone via Zoom?
Mayor, we have no raised hands.
I will close public comment and bring it back to the council for a motion.
I'll move to receive and file the report on new 2025 state housing laws.
Second.
We have a first and a second.
Sorry about that.
Yes.
Didn't know you didn't have the form.
What? Okay. We're good. We have a motion. We have a first and a second. All those in favor?
Aye.
Any opposed? Motion passes. Thank you, staff, for all of your work on this presentation.
You're very welcome.